An interesting development now in the Humberside Predatory police inspector story, as it seems that although now former Inspector Craig Mattinson was dismissed after being found guilty by a misconduct panel of gross misconduct last week, the Crown Prosecution Service have since confirmed that that case was never referred to them to consider criminal proceedings. Mattinson was accused of inappropriately touching two vulnerable young girls, one just 14, the other 17, back in April 2003, or between April 2003 and April 2005. He was said to have touched them both over their clothing and kissed the then 17-year-old, who said at the misconduct hearing last week that she recalled the officer putting his tongue down the back of her throat. Panel Chair Eileen Hurley concluded that sexual gratification must have been Mattison's primary motive. And when you consider his past, you can see a predatory pattern, such as the fact that in 2001 he admitted sending messages to a 15-year-old girl, and after a complaint by the girl's mother, Mattinson was given a superintendent's warning. 2003 he admitted to having sex with a victim of a burglary, for which he was offered management advice, which is nothing more than a so-called stern talking to. I mean, he should have been gone after being caught chatting to a 15-year-old. But Humberside Police Force allowed him to continue, which led to further instances involving the two then young girls who were sexually assaulted by him. But yet, Humberside Police felt that deciding if he should be prosecuted or not should rest on their shoulders rather than sending a file of evidence to the CPS. The IOPC said the case was referred to them, but following careful consideration of the available information, they directed Humberside Police Force to carry out a local investigation against one of their own. Humberside Police insisted correct procedures were followed, stating a successful prosecution was not thought possible. Humberside Police said in a statement, thorough inquiries were carried out and evidence examined in a bid to progress through the criminal justice process. Correct procedures were followed, however, the potential to secure a successful prosecution at court was not deemed as possible. Which kind of sounds like they, the police, made the decision whether to prosecute or not, as the case may be. But the CPS website states quite clearly that the role of the CPS is to prosecute criminal cases following investigations by the police and other investigative organisations, adding that decisions are made independently of the police. Now, could this mean that Humberside Police Force are now guilty of perverting the course of justice? It certainly sounds that way to me. However, Humberside Police have said that they have no further comment to make on the matter, which means that they're in damage control mode and will likely be searching out a scapegoat, some cannon fodder, should this go any further. Now, we all know that police feel like they have the power of Judge Dredd. We have probably all had an NFA to a complaint that we've made about something, simply because the police don't think it has the potential for a positive prosecution. But as we all know, these people are not solicitors or lawyers, and their knowledge of the law is limited. Very limited in some cases. So why are they allowed to make the decisions? Some cases we've seen that police have failed to send to the CPS have later been dealt with due to further reoffending, and the cases which were ignored by police have then been picked up on. This should not be allowed, and this practice of police making the decision should stop. Granted, if there's no evidence of an offence, then that would likely fail in a court, as courts rely on evidence. But where there is evidence or potential for evidence, the decision should not be made by the police, and every case should then be sent to the CPS to consider. Don't get me wrong, I'm glad Mattinson is out of the force, but he could have been and should have been dealt with after being caught out grooming a 15-year-old online, rather than allowing him to continue to assault 3 others.